Sumit Chander Advocate, Supreme Court. And is that why lawyers are upset, Sumit Chander ji, कि अगली तारीख तक हम पोस्टपोन नहीं कर पाएंगे? ये तारीख पे तारीख वाला एस्पेक्ट ही हट गया है, because there is a time limit.
No, that's not the reason. But let's be very clear here. There are various aspects. We are first the officers of the court. So now I can speak from the point of view as to what law is now come up and what the Supreme Court has said. Has it really gone against it or aligns with what Supreme Court has says? Now Supreme Court, like Learned DGP has rightly said, use of handcuffs. Supreme Court time and again in various judgments has held that using of handcuffs.
Sumit ji, go ahead.
Am I audible?
Yeah, now you are audible. We lost you momentarily. Please go ahead. So, using of handcuffs, what has the Supreme Court said? Ji.
Supreme Court says use of handcuffs is inhuman, unreasonable, arbitrary, and repugnant to Article 21 of the Constitution of India. Now, if Supreme Court makes such a statement and it's part of a constitutional right of every citizen, I think use of handcuffs should not have been there anywhere under the new act. However, in certain provisions, certain places, they have still allowed the use of handcuffs.
They've excluded economic offences out of the handcuffing.
Yes.
And petty crimes has also been, and also based on the seriousness of the crime and of course the deviousness of the deviant, I think there is some measure of who needs to be put under handcuffs and who can be excluded. So that somewhere is fair.
Now, if something is unconstitutional or against Article 21 of the Constitution itself, I think it has to be taken more seriously rather than casually allowing it in certain places. Secondly, even if I look at the new provision, which is Section 152, which now gives the new form to the sedition law, it's interesting where all the provisions allow in law giving the liberty to the magistrate or the judge to use his discretion as to what number of years should be given in imprisonment. Here now the new provision says it's either imprisonment for life or the punishment would be imprisonment which may extend to 7 years. Now it does not leave the discretion to the court to decide how much it is going to be, which is unreasonable here. Then again, Supreme Court in several matters have held that there should not be vague terms used. If I look at, and that was majorly in Shreya Singhal versus Union of India, where Supreme Court held that some provisions can be unconstitutional if the terms used are vague and devoid of precision. Now, if you look at the provisions used in the present new law, there are acts, there are provisions which clearly use vague terms, like the learned DGP had rightly said. If you look at Section 4F, which talks about community service as a method of punishment, but it lacks a clear definition of what activities would constitute community service. Similarly, Section 111, which relates to organized crimes, the explanation, it uses the word economic offences without a clear definition, vague such as financial scams, Ponzi scams, mass marketing frauds. Now, without providing explicit definitions of these terms, you cannot just vaguely mention that these are the offences or these are the schemes.
Okay. So, Sumit Chander ji, please respond. But again, community service, what is community service? Has it been clearly defined? That's a query that Mr. Sumit Chander raised and that remains. The other aspect is sexual assault. Is it being made only gender specific or does that remain gender neutral? If offences against a child or pedophilia or any other kind of assault against a child can be gender neutral, then in this, or the offender can be gender neutral. In this case, the larger question is, has sexual assault been defined only per one gender in the country and not, are the charges not gender neutral? That's another question that remains. Sumit ji, would you like to respond to Sanju Verma?
Learned BJP spokesperson has said that I'm just against it, against the law. Let me be very clear, with due respect, as a lawyer, it is my duty to bring out the loopholes in any law. And I'm only trying to ascertain whether the new laws are in line with the judgments and the constitution provisions which are already in existence. So now, say for example, I'll just say another point when it comes to sexuality and gender neutrality. Say for example, Section 377 of the old Act, right, which now has been totally removed. Fair enough, the government decided to do so. But let's see, 377 to totally remove, was it right? Because 377, besides other things, also covered certain provisions, certain specific provisions with respect to bestiality, for example. Now, bestiality is also an offense, used to be an offense, and there have been several instances of bestiality. In fact, latest even in times of in 2022, where bestiality offense was committed. Now, bestiality, sex against animals, sex with animals. Now, that unfortunately, however absurd it may seem, it is happening in the country. And that also is removed just because 377 in Navjot Singh Johar, Supreme Court said that yes, it can be, to a certain extent modified. So to mindlessly change things is also not right. So my as a lawyer is to just bring to the notice of the government that see, these are the provisions which could have been modified. Now, another very important aspect which needs to be seen, lot of other acts, the provisions of other acts depend on IPC. Where, say for example, the provision where it says the Juvenile Justice Act, Section 84, it says that for the purposes of this act, the provision of Section 359 and 369 of IPC would apply. Now, of course, those provisions have changed. So now, just by changing the entire act, changing the sequence of the provisions, the government also parallelly should have immediately amended the other provisions which were relying upon the IPC. So those aspects still need to be worked upon. It cannot just changed.